Thank you for joining us today and welcome to Smith, Gambrell & Russell's live webinar on the topic Sovereign Immunity, a General Overview, Recent Developments at the Patent Trial and Appeal Board and the Implications on Licensing. Today's webinar will be approximately 1 hour. If you would like a PDF copy of this webinar, please let us know. SGR's Stephanie Scruggs will be presenting today's webinar. Ms. Scruggs is the Managing Partner and Head of the Intellectual Property Section in the Washington, D.C. office of Smith, Gambrell & Russell. Ms. Scruggs is an experienced intellectual property attorney focusing primarily on complicated patent disputes. She represents clients across a wide range of industries in the enforcement of intellectual property rights and the defense of intellectual property disputes in federal district court, including Eastern District of Texas, the Eastern District of Virginia, and the District of Delaware, before the International Trade Commission and before the Patent Trial and Appeal Board at the United States Patent and Trademark Office. Stephanie will be discussing sovereign immunity and the role it plays in federal courts, as well as before the Patent Trial and Appeal Board. She will also discuss licensing considerations in view of recent decisions on sovereign immunity. Now I'd like to turn it over to Stephanie Scruggs to begin the presentation.
Good afternoon. Thanks very much for joining me today. Since Liz was kind enough to already introduce me, I'll just dive into the subject matter. So sovereign immunity has been a big topic in the patent world lately, mostly due to recent efforts by patent owners to assert a defense of sovereign immunity in inter-parties review proceedings before the Patent Trial and Appeal Board. I thought it'd be best if we start first with some background information on sovereign immunity and then discuss the defense as it has played out in federal court and more recently before the Patent Trial and Appeal Board, and then finish with some thoughts and considerations on licensing as it pertains to preserving the defense of sovereign immunity. But since patent law seems to be an area of law that's very heavy on acronyms, it's probably best if I run through what I will likely frequently use as acronyms during the next hour. When I say PTAB, I mean Patent Trial and Appeal Board, which is an administrative law body of the United States Patent and Trademark Office, and it's made up of administrative patent judges, which I could also refer to as APJs at some point during the presentation. The APJs decide on issues of patentability, either through post-grant proceedings, such as inter-parties reviews, post-grant reviews, and covered business method reviews, or through appeals relating to patent applications. The USPTO, or PTO, of course, is the United States Patent and Trademark Office. IPR is an inter-parties review. And a DJ is a declaratory judgment action, which is a court proceeding that allows a party to ask a court to make a legal determination to resolve legal uncertainty for the litigants. In the context of patent law, this may arise when a party receives a cease and desist letter alleging patent infringement, and that party would prefer to choose its venue before the complaining party files a complaint. So moving into some background information on sovereign immunity. Sovereign immunity for states and state entities come from the Amendment, which limits the judicial power of the United States so that it does not extend to suits in law or equity brought by a private party against a state. So what does this actually mean? We'll break it down a little bit with Supreme Court cases that have helped to interpret the 11th Amendment. The Supreme Court has interpreted the 11th Amendment to limit the judicial authority of federal courts to subject a state to an unconsented suit. More specifically, the Supreme Court has clarified that sovereign immunity exists to not only protect an unconsenting state from being sued, but also to protect an unconsenting state from being sued in a jurisdiction that they did not choose. So going a little bit further with the Supreme Court's interpretation of the 11th Amendment, in the 1997 case, Regents of the University of California against Doe, the Supreme Court held that the 11th Amendment extends to state agents and state instrumentalities. These state agents and instrumentalities are generally referred to as arms of the state. To determine whether an entity is an arm, you must first define the function of the entity and then apply a 4-factor test that's set forth in a Manders against Lee case from the 11th Circuit in 2003. Those 4 factors include: how does the state law define the entity? What degree of control does the state maintain over the entity? Where does the entity derive its funds from? Who is responsible for judgments against the entity? The Supreme Court has also found that lawsuits brought against employees in their official capacity may also be barred by sovereign immunity. The case I'm referring to is Kentucky against Graham, and it was decided by the Supreme Court in 1985. And the Supreme Court said that lawsuits brought against employees in their official capacity represent only another way of pleading an action against an entity in which an officer is an agent, and such they may also be barred by sovereign immunity. The Supreme Court has also interpreted the 11th Amendment to preclude certain administrative proceedings when brought by a private party. In arriving at this conclusion, the Supreme Court evaluated the proceedings before the Federal Maritime Commission and compared those proceedings to civil litigation to determine whether sovereign immunity would be applicable. In the Federal Maritime Commission case, the Supreme Court compared the role of the judge or the administrative law judge in the Federal Maritime Commission and an Article III judge in district court, and found that the roles were very similar. The Supreme Court also looked at other aspects of the proceeding: the discovery, the depositions, the motions, and then the final judgment of the 2 judges. And as a result, the court found that those proceedings were overwhelmingly similar and held that sovereign immunity could be used as a defense in that particular administrative proceeding. In affirming the ruling from the U.S. Court of Appeals for the 4th Circuit, the Supreme Court essentially adopted the lower court's view that the agency proceeding walks, talks, and squawks like a court proceeding for the purposes of the 11th Amendment analysis. So moving into probably a lesser known area, but it's been recently in the news, let's take a look at sovereign immunity for tribes. And briefly, federal Indian law rests on 2 core principles. Tribes possess inherent sovereignty, although their authority can be restricted through treaty, federal statute, or when inconsistent with their dependent status. And the second core principle is that Congress possesses plenary power over tribes, which means that it can alter or even abolish tribal sovereignty at will, including with regard to patent law. So the tribal sovereign immunity, which sounds very much like it, as when it's applied, very much like state sovereign immunity, flows from the tribe's sovereign status. In the Michigan against Bay Mills Indian Community case heard by the Supreme Court in 2014, the Supreme Court affirmed the court's precedent that Indian tribes possess sovereign immunity from suit for commercial activities conducted outside of Indian lands. It also affirmed the court's precedent that such tribal immunity can be abrogated only by clear and unequivocal congressional authorization or waiver. In a recent case, Lewis against Clark, just heard by the Supreme Court or decided upon by the Supreme Court this year, the Supreme Court made it clear that the protection offered by tribal sovereign immunity is no greater than the protection offered by state or federal sovereign immunity. So similar to state sovereign immunity, with tribal sovereign immunity, there is an arm of the tribe test. So what other entities fall under the tribal sovereign immunity other than just the tribe itself? It is very similar, as I mentioned, to the arm of the state under 11th Amendment immunity. But there are 3 main factors that are considered. Is the entity chartered under tribal law? Do proceeds serve to further the aims of the tribe's self-governance? And did the tribe intend to confer its immunity to the enterprise? The arm of the tribe typically extends to tribal casinos and commercial enterprises under this test. However, the Supreme Court this year made it clear that it does not extend to tribal employees sued in an individual capacity for negligence in state court under state law. And just to walk through this case a bit, the Lewises, the plaintiffs here, were driving down Interstate 95 in Norwalk, Connecticut, when a limousine driven by William Clark hit their vehicle from behind. Clark, who was a gaming authority employee, was transporting patrons of the Mohegan Sun Casino to their homes. The Lewises filed suit against Clark in his individual capacity in Connecticut State Court, and then Clark moved to dismiss the case for lack of subject matter jurisdiction on the basis of tribal sovereign immunity. For the purposes of the appeal, it was undisputed that Clark caused the accident. So the Supreme Court had to decide whether the sovereign immunity of an Indian tribe bars individual capacity damages against tribal employees for torts committed within the scope of their employment. So they essentially had to look at whether the sovereign, the tribe, was the real party in interest. And the court said that the suit itself was brought against a tribal employee operating a vehicle within the scope of his employment on state lands, but the judgment, any judgment that they would render, would not operate against the tribe. And that this was not a suit against Clark in his official capacity, it was simply a suit against Clark to recover for his personal actions. So it would not require action by the sovereign or disturb the sovereign's property. So the court found that sovereign immunity was not available as a defense with that particular fact pattern. So now that everyone hopefully has some valuable background on the basis for state sovereign immunity under the 11th Amendment and tribal sovereign immunity, I'd like to cover it in the more specific context of federal patent and trademark suits. So the Supreme Court has confirmed that the 11th Amendment is applicable to suits pertaining to violations of federal patent and trademark laws. However, when a state initiates an infringement suit, it has then waived its sovereign immunity with respect to that suit and has opened the door to any compulsory counterclaims that may be brought by the alleged infringer. And this was clarified by the Federal Circuit in 2003 in the Regents of the University of New Mexico against Knight. So going straight into the application of the sovereign immunity defense in federal court, the Federal Circuit has provided guidance on the scope of the use of this defense. One such example is TGIC Communications Corporation against the Board of Regents of the University of Texas system. In TGIC Communications, the plaintiff, TGIC, brought a declaratory judgment action against the patent holder, the Board of Regents of the University of Texas system. By way of background, there was already a suit pending in the Western District of Texas brought by the University of Texas against plaintiff TGIC's customers and licensees, but it did not name TGIC. So the plaintiff proceeded to file a declaratory judgment action in the Western District of Washington. The lower court dismissed the suit because the patent holder was a state entity that had not consented to the suit. On appeal, the Federal Circuit affirmed both the dismissal and the district court's decision not to transfer the action to the Western District of Texas, recognizing the district court's serious doubts as to whether the plaintiff TGIC could have brought the independent action in Texas separate from the ongoing suit in which the university was already a plaintiff. The Federal Circuit went on to say that since there was no question that the university had waived immunity in the action that it filed against TGIC's customers and licensees in the Western District of Texas, TGIC's proper recourse was to seek to intervene in the action in the Western District of Texas. In another instructive case, A123 Systems against Hydro-Quebec, a plaintiff filed a declaratory judgment action against a licensee of 2 patents owned by the Board of Regents of the University of Texas. The lower court, here the District of Massachusetts, dismissed the case for failure to join a necessary party because the licensee, Hydro-Quebec, did not have all substantial rights under the patents. More specifically, the license to the patents in the suit to Hydro-Quebec was only an exclusive field of use license, and that thus the University of Texas was a necessary party to the suit. However, because the University of Texas had not waived its sovereign immunity, it could not be subjected to the suit, and the suit could not proceed without the University of Texas. A123 appealed the decision of the district court, and the Federal Circuit affirmed the decision of the lower court and said that plaintiff A123 could not join University of Texas because the University of Texas had not waived 11th Amendment sovereign immunity. And then in further addressing the immunity issue, the Federal Circuit ruled that the University of Texas's waiver of sovereign immunity in a different patent infringement suit in a different district did not result in a waiver of immunity in the District of Massachusetts declaratory judgment action. In other words, a waiver of sovereign immunity by a university is limited to the dispute in which the waiver is made. For example, a university does not waive sovereign immunity in one lawsuit by later filing a separate lawsuit against the same party regarding the same patent in another jurisdiction. So moving to a recent case involving, and by involving, I think it's probably more tangential than the other two cases that we were talking about, but it does at least touch on tribal sovereign immunity in district court. We have Allergan against several generic drug makers. A bit of background here, Allergan sued these generic drug makers such as Teva Pharmaceuticals and Mylan and other pharmaceutical companies in the Eastern District of Texas over the span of a few months in 2015 and 2016. And the allegation was that the proposed generic version of Restasis, the dry eye drug, would infringe Allergan's patents on the drug. Recently, Allergan assigned those patents to the St. Regis Mohawk tribe and then moved to substitute the tribe as a plaintiff. Or in the alternative, join the tribe as a co-plaintiff. So while the defense of sovereign immunity was not specifically being asserted by the tribe in the case, the court did note that since the case was brought by Allergan seeking affirmative relief against the generic drug makers, any possible immunity from the suit that might be applicable to the tribe to avoid litigation has absolutely no application in the case. The tribe, through its predecessor in interest, Allergan, had waived its tribal sovereign immunity by initiating the suit. The court did go farther to explain that even assuming that the initial assignment of the patents from Allergan to the tribe was valid, the tribe would not be considered the owner of the patents if, through the exclusive license agreement, it had transferred all substantial rights in the patents, except for the right to receive royalties on the sale of Restasis. In that event, Allergan would be entitled to maintain the action on its own, and it would not be necessary to add the tribe as a co-plaintiff. On the other hand, if the tribe had retained substantial rights in the patents, even after the grant of the exclusive license to Allergan, the tribe would be a necessary party to the infringement action. The court eventually added the tribe as a co-plaintiff and made sure that it was clear that the court was taking the safer course in doing so, and that the ruling to add or to permit joinder of the tribe did not constitute a ruling on the validity of the assignment of the Restasis patents or the tribe's status as a patentee for the purposes of the Patent Act. The court said it was merely a discretionary determination by the trial court that the transferee's presence would facilitate the conduct of the litigation. And we'll see later in the presentation how Judge Bryson's comments in these two particular orders might play out before the PTAB as well. And on an interesting side note, Judge Bryson did also find that while Teva infringed the claims were invalid in the district court case. So now that the stage has been set from the federal court's application of 11th Amendment sovereign immunity and to some extent tribal sovereign immunity, we can turn to more recent happenings before the Patent Trial and Appeal Board. Since proceedings before the PTAB are administrative proceedings, it's important to remember our brief discussion at the beginning of the presentation about the Supreme Court's interpretation that the 11th Amendment does bar certain adjudicative administrative proceedings when filed by a private party. So before 2017, not much happened in looking at the administrative proceedings at the United States Patent and Trademark Office and whether sovereign immunity was available as a defense. However, we do have a case from 2007, Baskath against the curators of the University of Missouri, where the University of Missouri was attempting to use the defense of sovereign immunity once an interference proceeding went up to the Fed Circuit on appeal. The Fed Circuit was then faced with whether the claim of sovereign immunity was applicable in interference proceedings before the United States Patent and Trademark Office. And so the Federal Circuit looked back to the Federal Maritime Commission case and said, the interference proceedings were very similar to the administrative proceedings before the Federal Maritime Commission in that they bear strong similarities to civil litigation, and that the administrative proceeding could in fact be characterized as a lawsuit. But the facts here did not allow the defense to be used by the University of Missouri to avoid the appeal, because the University of Missouri had actually provoked the interference or the administrative proceeding and participated in the proceeding. And it was not available, the defense was now not available to shield the agency's decision from review. Fast forward 10 years, and we finally have a number of decisions before the Patent Trial and Appeal Board that help to better draw a picture of how sovereign immunity may be used in post-grant proceedings. So the first set of IPRs that we'll talk about is Covidien against the University of Florida Research Foundation. And then another one a few months later from Neochord against the University of Maryland, Baltimore and Harpoon Medical. And then two other decisions that have yet to be decided by the PTAB, but that everyone is keeping their eyes on because it helps to, on the state sovereign immunity issue, better complete the picture, and on an issue that has just recently come to light with tribal sovereign immunity at the PTAB. So looking at the first set of IPRs, Covidien filed petitions for IPR on 3 patents owned by the University of Florida Research Foundation. And this occurred after the University of Florida Research Foundation brought a lawsuit in state court. Prior to the deadline for the patent owner's response that is filed in response to the petition, the patent owner requested authorization to file a motion to dismiss based on the University of Florida Research Foundation's sovereign immunity. The PTAB authorized the filing of that motion, and the University of Florida then filed its motion to dismiss at the same time as its preliminary response. In opposing the University of Florida Research Foundation's motions to dismiss, Covidien argued that the patent grant is not a private right, but a public right, subject to all statutory conditions for its grant, and that the PTAB should really be viewing this inter-parties review proceeding as an in rem action similar to a bankruptcy action, and it directed at a patent rather than directed at a patent owner. Covidien also argued that the absence of monetary and injunctive relief does in fact matter for a determination of whether sovereign immunity applies. In response to these arguments, the PTAB noted that the inter partes means between the parties, and that the proceeding is directed to both parties over whom the board exercises jurisdiction. And the board wasn't persuaded that an inter partes review is an action brought by the federal government against a state. The board's role is not unlike the Federal Maritime Commission's role in FMC. So the PTAB held that the 11th Amendment immunity bars institution of IPR against an unconsenting state that has not waived sovereign immunity. It found no support for Covidien's argument supporting its position that a state's 11th Amendment immunity may be limited or abrogated by a public rights exception. It also noted that there are strong similarities between civil litigation in a district court and IPR that were not unlike those compared in Vascath, which was the interference case that went up to the Federal Circuit in 2007. And that included the role of the administrative patent judge, comparing that role to an Article III judge in civil litigation. They also looked at the estoppel provisions that come along with filing an IPR and found those to be very similar to what might occur in civil litigation. Once the PTAB determined that 11th immunity was available as a defense and a possible reason to dismiss an IPR, it then had to look at whether the University of Florida Research Foundation was an arm of the state of Florida such that sovereign immunity would be applicable. And it did so under the 4-factor test we discussed in Manders against Lee. And then it finally found that the University of Florida Research Foundation had not waived its sovereign immunity based on the state court suit. So the PTAB ultimately dismissed the petition prior to institution based on sovereign immunity of the patent owner. So moving forward a few months after the Covidien decision came out from the PTAB, we have another decision in another IPR filed by a company called Neochord against the University of Maryland, Baltimore and its licensee, Harpoon Medical. After, the distinction in this case is that the motion to dismiss filed by the University of Maryland, Baltimore only occurred after institution of the IPR. The University of Maryland, Baltimore, of course, had to seek authorization to file its motion to dismiss based on sovereign immunity. And the PTAB did express timeliness concerns and asked why the University of Maryland, Baltimore was waiting so long to file its motion to dismiss. University of Maryland, Baltimore did seek this authorization within 3 days of the Covidien decision and explained that until the Covidien decision came out from the PTAB, it was not aware that it could actually assert the defense of sovereign immunity in an IPR. So the PTAB ultimately authorized the University of Maryland, Baltimore to file its motion. And in its motion to dismiss, the University of Maryland, Baltimore argued that it was in fact an arm of the state of Maryland and that the 386 patent is property of the state, such that sovereign immunity was applicable and the IPR could not go forward. In opposition to the motion to dismiss, Neochord argued that the Covidien board erred in finding that sovereign immunity was available as a defense before the board. It also argued that the University of Maryland, Baltimore waived immunity by participating in IPR up through institution and through its licensing activity with its licensee, Harpoon Medical, and that the licensee was in fact paying for and controlling the defense of the IPR. So the University of Maryland, Baltimore should not be considered an indispensable party to the IPR, and the board could proceed without the University of Maryland, Baltimore. So in Neochord, the PTAB again held that the 11th Amendment immunity bars institution of the inter-parties review against an unconsenting state that has not waived sovereign immunity. The board did find that the Covidien decision previously issued months earlier was not binding on the Neochord IPR, but it again found that it was applicable in IPRs. The PTAB also held that the University of Maryland, Baltimore was indeed an arm of the state of Maryland, and it found that the university had not waived its sovereign immunity by participating in the IPR. In fact, the PTAB found no indication that the university had delayed filing its motion for tactical reasons, rather that it took at face value the university's stated reason for not raising the defense sooner, that before the Covidien decision, it had not been aware that it could raise the 11th Amendment defense before the board, and that it raised the defense within 5 days of the Covidien decision. The other aspect of this is that the board explained that the 11th Amendment defense could be raised at any time, and that mere participation in judicial proceedings or here administrative proceedings before the PTAB doesn't create a waiver unless the state has taken affirmative steps to invoke federal jurisdiction, such as filing suit as a plaintiff or seeking removal of a proceeding to federal court. In other words, when a state serves as a defendant in federal court without more, it generally has not waived sovereign immunity and remains free to raise the defense at any time. The PTAB also found that the University of Maryland, Baltimore had not waived its sovereign immunity through its licensing activity. So ultimately, the PTAB granted the motion to dismiss based on sovereign immunity and terminated the IPR. So moving to another body of IPRs that might help to complete the picture about how the defense of sovereign immunity may be used at the PTAB, we have the Erickson IPRs. So we now know from Covidien and Neochord that the defense of sovereign immunity is successful in an IPR that was brought after the patent owner initiated a state court case, and an IPR that was brought against a patent owner and a licensee where no corresponding district court case existed. But we don't know yet what will happen if the patent owner initiated a patent infringement suit in district court against the petitioner and now seeks to dismiss the IPR based on sovereign immunity. And this is where the Erickson against Regents of University of Minnesota IPRs come in. So by way of background, in November of 2014, the Regents of the University of Minnesota sued AT&T, Sprint, T-Mobile, Cellco Partnership, asserting the challenged patents that eventually will become the subject of the IPRs. Erickson was not at the time a named defendant. It was merely a vendor to the defendants. But on March 30th of 2016, Erickson successfully intervened in the district court litigations. And within 1 year of that intervention, Erickson filed 6 IPR petitions challenging the asserted patents. Having the Covidien decision from the PTAB available, Erickson went ahead and preemptively argued in those petitions that the university had waived its sovereign immunity for an IPR proceeding by filing lawsuits in the federal district court in Minnesota. The University of Minnesota, in response to the petitions, filed a motion to dismiss based on sovereign immunity, in which it argued that the waiver of sovereign immunity resulting from a state filing a lawsuit applies only to the compulsory counterclaims in the same action and in the same forum. It further argued that the IPR petitions are neither compulsory counterclaims nor adjudicated in the same forum. They are completely different action brought in a different forum. And then further noted that the Federal Circuit has made it clear that a state that files an infringement action does not waive its immunity from a different action challenging the patent in a different forum. In opposing the university's motions to dismiss, Erickson argued that sovereign immunity does not apply or was already waived with respect to patent office proceedings on the patents. And the basis of that argument was the university came to the patent office, they asked the patent office to grant them a patent, and so therefore there should be no sovereign immunity applicable with regard to another proceeding before the office. Erickson also argued that once the state university avails itself of federal district court, it also subjects itself to all mechanisms available, including all statutory mechanisms and rights available to Erickson related to that action, and said that the IPR proceeding is such a statutory right. Erickson also pointed out that the university had stipulated to Erickson's intervention in the vendor suits, and so therefore it was considered to be a compulsory counterclaim from Erickson. So on this one, we'll have to, the briefing is now complete. And in fact, the reply brief by the university was filed in July of 2017. Since it's now November 1st, the board hasn't yet ruled on this motion to dismiss, but it did allow the deadline for the preliminary response by the patent owner to be extended 1 month after the issuance of the decision on the patent owner's motion to dismiss. So it is taking some time for the board to decide on this issue, but hopefully once the issue is decided upon, we'll have a more complete picture being drawn with regard to how state sovereign immunity will play out at the PTAB. So moving to tribal sovereign immunity before the PTAB, we have one case to keep an eye on with regard to the success or failure of this defense at the PTAB. So just a little bit of background on this. The Mylan IPRs that are referred to in this slide are the same, they involve the same patents that are at issue in the Eastern District of Texas case that we discussed previously, the Allergan against the generic drug makers. Mylan filed IPR petitions on 6 patents owned by Allergan related to the Restasis drug. And after the December 2016 institution of the IPRs, the patent owner Allergan assigned the rights to the patents to the St. Regis Mohawk tribe. And that happened in September of 2017. The tribe licensed them back to Allergan in exchange for a lump sum amount and future royalties. After being assigned the patent, the tribe then filed a motion to dismiss the IPRs based on sovereign immunity. It argued that it retained, under the license back to Allergan, that it still retained substantial rights to the patents, and that the assignment of the patents to the tribe was a valid assignment because no consideration was required beyond a simple acknowledgement of consideration. So diving a little bit further into this, there is a lot of commentary out there on the actual assignment between Allergan and the tribe and whether this is an actual, whether this is a transaction that should be upheld or not. And I'm sure that the PTAB is going to be looking more specifically into those issues to decide whether sovereign immunity is applicable or not in this case. Mylan, in opposing the motion to dismiss by the tribe, argued that certain distinctions exist between this specific case and decisions like the one we discussed in Covidien and Neochord. It also argued that the tribe was not, in fact, the patent owner, that there was no transfer of all substantial rights, that it's simply a sham transaction, and that the assignment must be void because it undermines the America Invents Act. It further argued that the tribe is not an indispensable party to the proceedings, and that IPRs themselves are not subject to tribal immunity. According to tribe, the petitioners didn't contest, the petitioners here being Mylan, they did not contest that the tribe is a sovereign entity protected by sovereign immunity, and that the tribe's immunity had not been abrogated or waived. So the decision by the PTAB will likely come down to whether this assignment is a valid assignment, whether the rights that were transferred were sufficient to consider the tribe the patent owner and then be able to assert the defense of tribal sovereign immunity. Interestingly, in the corresponding district court case that we discussed in the Eastern District of Texas, while sovereign immunity was not the issue in the case, Judge Bryson took the opportunity to opine on the issue anyway and expressed serious concerns about the legitimacy of the tactic that Allergan and the tribe have employed by assigning the patents from a private company to a tribe and trying to avoid IPRs. The court said it had serious reservations about whether the contract between Allergan and the tribe should be recognized as valid rather than being held void as being contrary to public policy. The court also said that it had serious doubts that the transaction in which Allergan has sought to obtain immunity from inter-parties reviews by the PTO in exchange for payments to the tribe is the kind of transaction to which the tribe's sovereign immunity was meant to extend. So it remains to be seen whether the PTAB will view things the same way that Judge Bryson does, and we'll just have to stay tuned for that ruling on the tribe's motion to dismiss. So based on the body of PTAB decisions that we have and the ones that are still percolating up for decision, we have some unanswered questions. One would be, are these decisions on sovereign immunity appeal proof? Well, in the Cuozzo against Lee Supreme Court decision, the Supreme Court held that the PTAB's decision to institute or not institute IPR is non-appealable. But are the PTAB's decisions on sovereign immunity appealable? And based on the fact that the Supreme Court left open the possibility of review of these decisions that implicate constitutional questions or that depend on other less closely related statutes, my guess would be they probably are appealable, but no one has done so yet. Especially since sovereign immunity is based on the 11th Amendment and tribal sovereignty is recognized and protected by the US Constitution, institution decisions or termination decisions based on sovereign immunity clearly involve a constitutional question and probably fall within the carve-out that the Supreme Court created in Cuozzo. Another unanswered question: are these recent PTAB decisions applicable to other proceedings before the Patent Trial and Appeal Board? So Covidien and Neochord address the applicability of sovereign immunity to IPR proceedings, but it's not clear whether these would be applicable to post-grant reviews or covered business methods. And again, the answer here is yes, these PTAB decisions are probably applicable and helpful in arguing if the same issues were faced in a PGR or a covered business method, because those PTAB proceedings share strong similarities to IPRs, and the PTAB would likely find that sovereign immunity or the defense of sovereign immunity would be applicable in those proceedings. So another question would be, is there a waiver for a state-initiated infringement suit? And this goes back to the Erickson IPRs that we're still waiting a decision on. So Covidien demonstrates that state entities who initiate litigation in state court do not waive their sovereign immunity to an IPR that the state court defendant may later file. But does the state entity waive sovereign immunity for a later filed IPR if it initiates infringement litigation in district court? And the answer to that, best guess, is maybe. The Patent Trial and Appeal Board may consider that district court litigation and IPRs more closely linked than two separate district court actions in different jurisdictions, given the stay and estoppel provisions. But again, we'll just have to stay tuned for the PTAB's ruling on Erickson's motion, on the university's motions to dismiss and the Erickson's IPRs, so that we can have a more complete picture drawn. Another unanswered question is, if an exclusive licensee brings and successfully maintains suit against an alleged infringer in district court without the university patent owner, would the sovereign immunity defense by the university prevent an IPR from being instituted or proceeding after institution? So my guess here is probably not, because if the exclusive licensee was able to bring and maintain after a potential attack from the defendant with regard to failure to name all necessary parties, then that probably means that exclusive licensee has all substantial rights. And the PTAB would likely consider in that scenario that the patent owner doesn't have, it's not a necessary or indispensable real party in interest, because all of the substantial rights went to the exclusive licensee. And in that case, it would likely allow the IPR to still go forward. So key takeaways from what we've already discussed. Covidien and Neochord, they are great templates for entities that want to assert sovereign immunity. But both of these decisions are non-precedential. So patent owners have to present the entire argument as to whether sovereign immunity should apply for IPRs, the fact that the entity is an arm of the state, the fact that the entity hasn't waived sovereign immunity, and just walk through all of the steps that are required to argue that the defense is applicable and should be used in that particular IPR. Key takeaway number 2 is that you need to pay close attention to state law. The PTAB noted in Neochord that the mere fact that an IPR has been instituted and that the university participated in proceedings didn't mean that the patent owner waived the defense of sovereign immunity, but it also noted that state law differs. And so that state law applicable to the patent owner may change whether the patent owner waived the defense by participating in proceedings. So make sure you pay close attention to state law. Another takeaway is that a non-exclusive licensee of a patent owned by a state university now seems to have non-legal mechanisms for enforcing its patents, provided the license agreement allows it to do so, without the fear that the patent will be subject to a counterattack through an IPR. So for example, a non-exclusive licensee could send out a cease and desist letter to an alleged infringer, and that alleged infringer should not be able to actually have an IPR instituted because the university has not waived its sovereign immunity with respect to that proceeding. However, I will note that a non-exclusive licensee of a private university would not find that same protection. So now, the discussion up to now has been focused on what federal courts and the PTAB has done when faced with a party asserting the defense of sovereign immunity or tribal immunity. So I'd like to finish up our time today by spending a little bit of time talking about some thoughts on licensing in view of these decisions in federal court and before the Patent Trial and Appeal Board. So we already discussed the A123 Systems against Hydro-Quebec case, where the defendant was a licensee and the court dismissed the case because the patent owner was found to be an indispensable party in the suit, but had not waived sovereign immunity. So if you're crafting a license, either a non-exclusive license or an exclusive license where the licensee has rights only within a certain field of use, you should think about including provisions in your license to clearly outline how future patent litigation will be handled. For example, if the license waives immunity with regard to future suits, then the defense of sovereign immunity will not be available in district court, or depending on the board's decision in the Erickson IPRs. And so looking at this more specifically, the Supreme Court has made it clear that the entity itself only waives its immunity if it's expressly waived in the contract, and it won't it won't usually look at a contract and see an implicit waiver of the immunity. So that's helpful, but you also want, in addition to avoiding any provisions that would expressly waive immunity in future patent litigation, for example, the university shall initiate, where it may legally do so, or defend patent infringement litigation in connection with the licensed patent. You should also be very clear that if you are agreeing to be named as a nominal plaintiff in any future lawsuit, that you do so only when you're declared to be an indispensable party by a federal court. So moving into exclusive licenses, as we've talked about, an exclusive licensee with all substantial rights can usually maintain a suit and survive an attack on failure to name all necessary parties without the involvement of the university patent owner. And so if the desire is for the university to participate in any potential future infringement suit or be able to use the defense of sovereign immunity in district court or before the PTAB, the exclusive license agreement should really be drafted to allow the university to retain at least some level of control over future enforcement efforts, among other rights. And this may allow the exclusive licensee to argue that the university is a necessary and indispensable party to the suit, and then argue sovereign immunity to have the suit or the IPR dismissed. So we had talked a little bit about what waivers might be dangerous in a license, what you should or should not avoid. And one instructive license that we can look at here comes from the Neochord IPR. And in the Neochord IPR, the petitioner Neochord argued that the University of Maryland, Baltimore had waived sovereign immunity in certain sections of its license agreement based on what it provided to its licensee, Harpoon Medical. So I've included some of those clauses here. And it basically says that University of Maryland, Baltimore would agree to allowing the patent to be put into re-examination rather than having a challenge in district court. And the petitioner Neochord argued that, well, look, the University of Maryland, Baltimore waived their immunity here, so therefore they waived it with regard to the IPR that we have now filed. The University of Maryland, Baltimore, in its counter-argument, said that that section that you're referring to, Neochord, only waives immunity with respect to the challenges by Harpoon Medical only, and that we have a savings clause in here. This section 14.6 expressly reserves the defense of sovereign immunity. And so in reading that clause, it basically acts as a fail-safe. So if you have more specific clauses where you are waiving sovereign immunity with respect to your licensee, you always want to include this savings clause. And this one reads, no provision of this agreement shall constitute or be construed as a limitation, abrogation, or waiver of any defense or limitation of liability available to the state of Maryland or its units, and so on and so forth, including without limitation the defense of sovereign immunity or any other governmental immunity. So our lessons learned from the Neochord license discussion is that the PTAB did in fact hold that that section that Neochord was arguing was a waiver by the university was a limited waiver only with respect to the licensee, and that the section 14.6, which is the section I just read, operates as a savings clause to preserve the defense of sovereign immunity with respect to other parties other than the licensee. And that states may enter into contracts that affect a limited waiver of sovereign immunity, for example, with the parties in the contract, but that doesn't open the door to suits from others. It is not a more general waiver of sovereign immunity. But again, avoidance of any type of limited waiver is probably the best course of action. And if you do have to put those limited waivers in, just make sure that you have a savings clause where you expressly reserve the defense of sovereign immunity. Also looking at retention of rights, the license provisions that you can put into your agreement that will help show that the university has retained sufficient rights such that it can use the defense of sovereign immunity to stay out of an IPR proceeding. Again, looking at Neochord. Neochord had argued that the licensee, Harpoon Medical, was really the real party in interest to the IPR, and so therefore the university was not a necessary party and the defense of sovereign immunity didn't matter. The University of Maryland, Baltimore then, in rebuttal, provided numerous license provisions to show that it had retained sufficient rights under the license to still be considered a patent owner and then apply the defense of sovereign immunity to avoid the IPR. So for example, section 9.5.1 of that agreement said that the university retains the right to sue a third party for infringement if the licensee failed to do so. It said that the university may practice the patent. It might license the patent to government agencies, that the licensee has to pay a portion of the royalty on any sublicense granted, that it shares in the recovery for patent infringement, that it must pre-approve a settlement, and that it may respond to legal action if the licensee fails to do so and reserves the right to intervene in any action involving the patent. The PTAB, in looking at these two arguments from the two parties in Neochord, held that the University of Maryland, Baltimore did in fact retain sufficient rights under the license and transferred less than substantially all rights to the licensee, such that the university was a necessary and indispensable party to the IPR, and that the IPR could not proceed without the university. So careful drafting of the provisions retaining rights is key to maintaining the status as a necessary and indispensable real party in interest for IPR if considering the sovereign immunity defense. But to note, the board in Neochord outlined what interests were considered to be enough for the university to be considered the necessary and indispensable real party in interest, but it didn't opine on what interest will not be enough. So we just sort of have to read through the lines and see that what the University of Maryland, Baltimore had in its agreement was sufficient to have been considered to have transferred less than substantially all rights, but there's no template to show how few rights you can maintain and still have the PTAB consider the university still the patent owner. So I think we are just about out of time. I very much appreciate your time today. If you have any questions, my contact information is at the back of the presentation. If you would like a PDF, as was mentioned at the early part of this webinar, feel free to reach out to us and we'll provide that PDF. Thanks again for your time today.
Thanks again for joining us today. Again, if you'd like a PDF of this webinar, please email sgrcommunications@sgrlaw.com and we will send you one. For more information on upcoming webinars or events, please contact the same email address, or you can visit our website at sgrlaw.com. Thanks so much and have a great day.